Thank you for coming today to discuss media access to juvenile dependency courts and the ethical responsibilities of journalists covering those courts. I want to thank the Chief Justice Earl Warren Institute on Law and Barry Krisberg in particular for letting us do this here. I want to thank the law school also for allowing us to do this here, and Marianne Mason, who's over there, who introduced me to Barry, which made this possible. So thank you very much. I see a lot of familiar faces here. We've got Judge Colfax here from San Francisco. We've got Chris Wu from the Administrative Office of the Courts. We've got Ed Opton, Bill Grimm from Nickel. We've got Jan Lee from the National Association of Social Workers. We've got Crystal coming down all the way from Reno to represent the National Council on Juvenile Court and Family. Juvenile and Family Court Judges. So I think we've got some of the right people in the room. We've got Peter Schuyler from KQED as well, and we've got other members of the press here with us too. So the reason why we thought to do this was pretty simple. I think that as a journalist covering the system and then beyond in this weird life that I've taken, I've seen the greatest inhibitor to increased interest in reforming the system in being a lack of understanding in the general public, and I think that that is largely written in the isolated cases of tragedy that become the headlines of so many stories. And I think that when you go outside of this room probably and talk to people in the general public, their impression of the foster care system and the child welfare system is that it's broken or ailing or not the full story of what it is. And I think that a part of that is an ability or a predisposition to not share information as freely as with other fields. I think that that is driven a lot of times by real serious considerations of not divulging the secrets of a child's life that could be very harmful, but I think it creates dangerous situations. And before I invite up Barry, I'm just going to tell a little story which I think kind of epitomizes what I'm saying. I was covering foster care for the LA Weekly, and I had heard about the LA Times had broken a story about these social workers in a mentoring division who had taken monies and tickets to certain shows, Wicked included, and they'd used this apparently for their own benefit as opposed to helping out the kids. So I wrote a very scathing story that went after the mentoring section, and years later I ran, and I did that because I got no information from the department. They wouldn't give me any information. I got frustrated, so I filled out the information that I could by talking to everybody else, and that was in a vacuum, and the people with the most information just didn't give it to me. And on the back end of that, years later I run into a former foster youth who tells me that one of her favorite social workers, the whole mentoring division that he had set up was kind of dismantled after that spate of stories. And then years later I ran into this man, and he tells me the same thing. So, you know, that coverage without full access, and we're not talking about the same exact kind of access, but this kind of predisposition to not share everything, I think can hurt even journalists with good intentions. So what I'm hoping we'll do today is just talk about this issue of media access to juvenile dependency courts, hear from really the top experts, and I really feel honored that you guys made it up and that we have people in the room listening to this. So first we've got Barry Krisberg step up and give us a little rundown of the history of the juvenile courts.
So my assignment is to cover 100 years of juvenile court history in about 5 minutes, which I will try to do. Probably the greatest American scholar of jurisprudence, Roscoe Pound, wrote that the American juvenile court was the greatest step forward in Anglo-American law since the Magna Carta. I remember when I first read that, I thought, wow. That's a bit of an exaggeration. But as I began to understand and do my own research and really understand this, I began to see what Pound was talking about. He was talking about a concept of justice. Now we tend to talk about it as therapeutic justice, but the notion that the justice system could be compassionate, caring, could be individualized, and could be the kind of justice system that if our own children or grandchildren were in trouble, would be the kind of justice system we want for them. And I think Pound correctly understood that. The juvenile court's come a long way. Most of our laws regulating juvenile court and family court in this country began in the later half of the 19th century. And interestingly, before we had a concern over protecting children, more politically palatable and popular was protecting animals. So the Society for the Prevention of Cruelty to Animals preceded a similar society for children by many years and actually became the basis of that movement. The American legal system struggled with this issue because on the one hand we had this principle rooted in American traditions like slavery, which valued people owning people, in this case parents owning their children. On the other hand, recognizing that just like in some of the slave law, slave owners couldn't do anything they wanted, that was kind of troublesome to the system. So for a lot of the early cases, the courts were struggling with this balance between the rights of parents, sort of unlimited ability to do whatever they want to their children, and society's interest to do something different. Now, the early proponents of child protective services and the early efforts were really not very nice people. They were people who were principally anti-immigrant, especially anti-Irish. They were mostly concerned about a phrase which was really popular in those years, the dangerous classes. And their principal motive was, as conservative reformers, they were concerned that this unwashed masses were going to overrun American society. As one famous reformer said, elect our future presidents, what a horrible thought. So the original instincts were not very progressive, enlightened, not even that child-oriented. It was mostly thinking about these drunken, depraved immigrants and what they were doing to their kids and how we white Anglo-Saxon Protestants had to get control of this situation. That changed pretty dramatically in the turn of the century when a different set of thinkers, most notably the Chicago philosopher John Dewey, who's probably better known in the education arena, but also giants of American social work like Jane Addams, Julia Lathrop, and others, began lobbying to create the American Juvenile Court. And in 1899, simultaneously in Illinois and in Colorado, America created its first juvenile court. And the essence of this juvenile court was its informality, its problem solving, now we think of that, that's a phrase we use a lot, approach, where the judge would work with the youth, with the family, and try to come up with a reasonable kind of solution. So a lot of the procedure, or lack thereof, in fact, a lot of the cases use phrases like, without any process at all, came out of this philosophy of the individual judge trying to work with the individual youth and family to come up with a solution. And so a lot of the early procedures, particularly the concern about privacy and keeping the press out and trying to mask these proceedings in quite a bit of secrecy, came out of this notion that it was really hard to do this sort of individual problem solving if you had the media sitting in the back bench, if you had to be playing to the to audiences, and so a lot of it came out of that, I think, pretty reasonable sense that if I really want to help families and reunite kids with their families rather than pull them out and put them in orphanages, I needed this kind of court system. I needed much more protection. Now the other thing I would just say is, keep in mind we're talking about rules and procedures developed at the beginning of the 20th century when there weren't that many cities, even things we think of as cities were a fraction of their size right now. And a lot of this country was either small towns, rural areas, where everybody knew everybody, and where a lot of this information would easily get around and be out there. So the juvenile court felt pretty firmly in its early stages that you needed to preserve this privacy, confidentiality, and informality to do its work. Later on, with the assault on the juvenile court, led mostly by conservative politicians, a lot of that was lost, and many states gutted confidentiality, privacy regulations, because at that point there was a pretty strong voice that said, you know, let's just get rid of this system. You know, why do the crime, do the time? Why do we need a separate court for children? They're after all just little adults, so let's do that. And so in a number of states we began weakening, not all, but some of these requirements. The one thing I want to, so that's kind of my quick and dirty history of how we've come to this place, which is a kind of uncertain place, because I'm not altogether clear we know where we're going from here. And I think it's very important as part of this conference that we begin defining that. The one thing I will leave you with, though, is, to me, the irony that a system that was essentially set up to protect children and families has too often been used to protect workers in this system. And the child welfare system has been and continues to be in chaos and disarray in most of this country. And you have underpaid, understaffed, underqualified, under you name it, folks doing this. Lots of problems. Years ago, they almost killed me in New York when I pointed out that it was more dangerous to be in the child welfare system than on Rikers Island for a young person. So again, this is a system in chaos and disarray. At one level, I think most of us would agree, the only way you can reform that system is to open the windows and doors and have people understand how bad it is and how incompetent it is in protecting children. But on the other hand, we don't want to give up on the privacy and security issues affecting families. So that's, I think, the challenge we have, and I certainly would agree that what we're talking about today is maybe a pathway through those challenges. So thank you very much.
Thank you.
Thank you, Barry. So I don't have a name tag, but my name is Jamie Kapalko, and I'm a third-year student at Harvard Law School, and I was able to work with fostering media connections from January to May of this year, researching this issue. And I was able to come out here in January, and then I did my project throughout the semester through the child advocacy program at my school. So I'm going to talk about my research, and the first thing that I'm going to talk about is the state of the law around the country. And juvenile dependency courts are presumptively closed in 28 states and presumptively open in 24. I know that's 52, but trust me. Most of the statutes don't actually refer to the press at all. They just refer to the public and apply the same standard to the public as the press. But there are a few states, I think Illinois and a couple of others, that are presumptively open to the press but presumptively closed to the rest of the public. And in general, a statute establishing a presumptively closed court says basically that the default is that the press and the public can't come in, but the judge has discretion to permit a journalist or someone else to attend when they have a proper or legitimate or direct interest in the specific case or the work of the court. And there are some states that have more restrictive standards than this, that only allow people in extremely compelling circumstances, but that's the typical language. And presumptively open statutes usually allow the members of the press or the public to attend as a default, but the judge has discretion to either disallow individuals or close the hearing to all members of the public, usually with some standard involving the best interest of the child. And some statutes, again, are more open than this. Minnesota only allows closure in exceptional circumstances, and the judge has to make a finding on the record explaining why he or she closed it. And some statutes, both open or closed, only allow journalists in if they'll agree to not to publish identifying information about the parties. There might be First Amendment issues about this, but it's not totally clear. It hasn't been decided. And some states allow openness for certain parts of a hearing, but require it to be closed for other parts that usually involve discussion of extremely sensitive information. So there's some variety among the states. So now I'm going to talk about California for a little bit. And the California statute has the typical presumptively closed language that I just discussed. But at least one appellate court has interpreted that language to allow journalists in unless there's a reasonable likelihood that such access will be harmful to the child's best interests. And really the language of these statutes gives a lot of discretion to the judges. So it can vary, application of the statute can vary from county to county and judge to judge. And when Judge Nash talks, I'll let him explain his order, which sort of lays out the standard that is applied in Los Angeles County. So the two other states that I looked at closely were Minnesota and Arizona. And Minnesota, as I said before, requires exceptional circumstances to close the hearings. And Arizona allows hearings to be closed for good cause and lays out some different factors for deciding what that means, and requires people who attend not to divulge identifying information. And the reason that I specifically looked at those states is because they did studies of their open courts, and both studies really found that there wasn't much of an impact when they switched to open from closed to open. That journalists didn't really attend and that children weren't really harmed. So the next step of my project was to interview a lot of people, some people in this room, judges, journalists, people who work directly with children. I tried to get all the stakeholders. And basically what I know the next speakers are going to talk about these issues, but I was trying to get out all of the pros and cons of open courts and from a neutral perspective. So that's part of what's in the report that you may have if you took it from outside of the room. So the two main competing ideas that came out from these interviews were a fear of harm to children and a belief that press access and attention will increase the accountability of the people who work within the system, and the idea that press coverage can lead to reform. So that kind of led us naturally to the Code of Ethics, which is also in the packet that you have. And we put that together. We thought of it as a way to encourage journalists to cover the courts responsibly, learning about the system, understanding how vulnerable the parties are and treat them with respect, and avoid sensationalism. And if journalists are agreeing to or following that Code of Ethics, it might give those who are opposed to open courts less to fear, and it might strengthen the coverage that we get from the courts. So I think now Daniel's going to come up and introduce the next speakers.
Yep. Thank you. So Jamie did a lot of amazing work on this and helped us get to the place where we could create this Code of Ethics that we hope does cut through a little bit of the fear and create a feeling of trust between journalists and the child welfare system. Whether or not that will happen, we don't know. We've been allowed into 5 jurisdictions using that Code of Ethics. So little by little, we're moving forward. But, you know, of course, there's real big concerns. There's benefits and there's costs and benefits to this. So I wanted to hear from Lily Dorman Colby, who are you, and Chantel Johnson to talk a little bit about those costs and benefits. So we'll start with Lily, and we're going to hear her opinion, and you can introduce yourself more fully. I don't think this thing's working. I'm just talking loudly. And then we'll hear from Chantel, okay? Thank you.
Hello. Good afternoon. Thank you, each of you, for coming here today. It means a lot to me to see so many passionate people caring about this issue and foster youth in general. I am a former foster youth. I grew up here in Alameda County. I'm also a former foster parent. My younger brother has autism, and at one point they couldn't find a home for him, and I was 18 years old and became his foster parent less than a year after exiting care myself. I wanted to talk a little bit about why I think that we need as much strength to foster youth and former foster youth in advocating for change as possible, and how journalism might be one of those areas. In my case, I've had a lot of experience with media. In high school, I was on the Berkeley Unified School District Board of Education, so I was regularly interviewed by the then Berkeley Daily City paper, and the Daily Planet, and I interacted with the news regularly. I was somebody who cared about making changes for other foster youth and other youth who had disabilities. I'm dyslexic, or who come from low-income communities like South Berkeley and East Oakland and Richmond. But not all youth want to get their name in the paper, or want their quotes in headlines, or want to do that. A lot of people are like one of my brothers who doesn't want to be in the news at all. So how can we bring attention to these issues and not exploit children, right? Not make children the center of news pieces that they don't want to be the part of, while also bringing attention to some of these drastically important issues. Foster youth can be arguably one of the most vulnerable populations in the country, and the most impacted by government policies. You know, I'm learning about housing law and how tenants have 30 days to, 30-day notices, and foster youth, we get 7 if we get any. That's not fair. But there are so many different issues that affect foster youth. With only 50% of us graduating from high school and 2% of us graduating from college, there's so much more that needs to be done. And what I have seen with journalism is the voice of foster youth through organizations like California Youth Connections and Fostering Media Connections, and through articles in the San Francisco Chronicle, like John Diaz's piece, make change. Our stories can make a difference. So in my brother's case, and my brother was one of the youth that was caught in the gap, the 80-12 gap, and he wasn't going to receive care. He was going to be exited from the foster care system on his 19th birthday, and he has high-functioning autism and wasn't ready to be on his own, and I was going to become his foster parent again and have to take care of him right before finals in my first year of law school, and this was a crazy situation, right? And because I knew Daniel, and then he met my brother, there was an article about his situation, and it totally changed the direction, having a lot of people get involved. And there was already a group of youth working in California Youth Connection on AB 1712, but adding an opinion piece in the San Francisco Chronicle to the mix, John Diaz's piece, and the work that my brother's attorney was doing in the courtroom, it all kind of coalesced to a change in the Capitol. And you never know what the straw that broke the camel's back was, or the thing that was the most important, but it made a huge difference. In what we're doing today is finding a code of ethics, a way that we can protect youth from having their names published, but to allow access so that way these issues, there's light into the courtroom. I think that I've read through the code of ethics and I've thought about it a lot. If youth don't want their name publicized, under the code of ethics, they're not publicized. If they don't want the journalists in the courtroom, they're not allowed in the courtroom. These are a lot of restrictions to help protect young people who might not want media coverage, but they also provide the ability to walk into these courtrooms and find some accountability, because we have laws on the books that are getting broken every day in these courtrooms. And we need somebody to help protect these kids. Thank you very much for being here, and have a great afternoon.
We're going to hear also from Chantel Johnson, and Lily talked about this idea of moving things forward, but you know, of course, there's big concerns, right? And Chantel's with the California Youth Connection, an organization which I'm happy to be on the board of, so I'm stuck in a very strange position. But I think that you know, you can tell us what those concerns are, and they're very valid concerns.
Absolutely. Good afternoon. Thank you, Daniel. As he said, I am the current legislative and policy coordinator for an organization called California Youth Connection. For those of you who are not familiar with California Youth Connection, we are a statewide advocacy organization with 33 chapters kind of statewide, where youth come together to create legislative and policy change to benefit the foster care system. I also have familiarity with the system like Lily. I am a former foster youth from here in Alameda County, and I'm also a relative caregiver to my soon-to-be 4-year-old niece, who was actually severely abused in foster care and had media coverage, so I have a lot of perspective from that angle as well. As Daniel kind of mentioned, CYC has been historically opposed to open courts, and not just recently. Recently we opposed AB 73, but we've been opposed to the idea of open courts as it's been presented to us kind of across the last decade. This is not a kind of a new idea. It's been something that's been up for debate for a very long time. One of the biggest thing that is a concern to the members of CYC is, of course, privacy. You know, their right to privacy on education matters, the matters of their abuse, their family's privacy. You know, the courts that deal with children and youth have historically been closed, as was mentioned, because of concerns of privacy breaches and re-victimizing children and youth in foster care. One of the things CYC believes is that that existing law really just goes far enough. As it currently stands, as was mentioned, the courts are presumptively closed, but can be open under certain circumstances. And we've seen that over, such as in LA right now, and Santa Clara, we've known that the courts have been open in the past so that media can get into the courtroom and present some factual data to the members of the public to kind of relay the story of what children and youth in foster care are actually facing. Well, one of the things that CYC has been really focused on is that not only that we believe that media is already allowed to have access, but that we already have enough recommendations for change in the foster care system, that there's no secret to what is actually going on, that social worker and attorney caseloads are really overwhelmed. We already know that that's a problem. So we're just we could potentially be exposing these youth to problems that we already have seen and have developed recommendations for. That's just one of the things. It's also been said to CYC youth that, you know, we may just be afraid of the unknown. That if we open the courts to the members of the public and the media, you know, that there's no real data that says that this, you know, from the data that we've seen in Minnesota and in other states, that we have no real data that says, okay, this could be harmful to the youth. And one of the significant differences that we've seen in the study, such as Minnesota, is that youth in California actually attend court hearings. So that we're comparing sort of apples and oranges. When reporters are going into courtrooms and speaking about writing a story about somebody who is in fact not there, it's very different than what California has done and what CYC has worked on to make sure that children and youth in foster care are actually involved in their court hearings and able to attend, even as far as changing the law to, you know, make the court hearings be rescheduled if the youth is not able to attend and has not been notified of that. Well, and finally, we just want to state that members of CYC, we do in fact have members that have said that they would want their court cases open, but they don't in fact believe that that the law should go as far as making that decision for everybody. That judges should consider the individuality of every case in foster care and treat that as an individual case, and that they should take into perspective making sure that the media and members of the public that do want access have gone through the necessary steps to say that they will protect the youth's privacy, and that they know that their obligation to the youth. So thank you very much.
About some of the theoretical concerns, and that there's of course a jurisdiction in this state that has been experiencing this for nearly a year now. So we invite up Judge Nash, Michael Nash, presiding judge of Los Angeles County Juvenile Court. I think it's the biggest in the world, biggest juvenile court in the world, correct?
No, it's big. Good afternoon, everybody. I'm pleased to be here with you today. And I've been a juvenile court judge for 23 years. In another month or so, it'll be 23 full years as a juvenile court judge. It's been one of the great privileges and prides of my life that I've had the opportunity to do this kind of work. I spent 15 years in the criminal justice system before I got to the juvenile courts, and there's no other court out there that helps as many people as we do in the juvenile courts. As I like to tell people when I talk about the juvenile court, we do good on a bad day. But that doesn't mean that we can't and shouldn't do better, and of course we need to do better. There's too many people yet that we don't help. And so that is one thing that has motivated me to stay in the juvenile court for so long, to see if we can find more and better ways to do the work that we do so that we can increase the percentage of people that we do help in this important system. Now, the issue that we're here to talk about today, the way I look at it is that I'm not going to argue all the pros and cons. I agree with some of the things that Chantel has to say, and I disagree with some of the things that she has to say. But we're looking at this differently. But from my perspective, I think we come from a society that values transparency, particularly transparency of its institutions and systems that it pays for, such as the child welfare system. And the public has a need and the right to know how our systems work and our systems don't work. I don't have the time here to tell you where I come to my perspective on transparency, but I will say this. Every time in my life as either a lawyer, a judge, or involved in other things where I have veered away from that value of transparency, it's caused problems. And so in my opinion, openness is always the best way to go. And I think the lack of transparency in this system has hurt. It's limited the public's knowledge about the system. That includes the good, the bad, and the ugly about the system. It's also limited the accountability of all of us. When I say all of us, that's judges included who work in the system. And in my opinion, transparency can help protect children from a system that all too often is not appropriately given them the services and the needs that need to be met on their behalf. Now, you know, for more than 20 years, I've worked to try and move this battleship of a system, and to a certain extent, in certain ways, we've had some success. But as I said, we still have a long way to go. That's a big battleship that we're dealing with. And one of the things that I feel is that we need some help. We need some help, and I think that shining light on these courts is a way that can help us move that battleship. Now, we know that there's no consensus on change on this issue in California. 3 times in the last 10 or 12 years, we've gone to the legislature to see if we could change the law in California with respect to openness or lack thereof of dependency courts. And each time, as I say, there are some child advocates that favor it, some that don't. There are judges that favor it, there are judges that don't. There are child welfare departments that favor it, child welfare departments that don't. We've never achieved a consensus in California. The last time with AB 73, I had the opportunity to meet and chat with a terrific lawyer who's present in the room today. I won't embarrass him, but he said, you know, I think, you know, some of what we're trying to do here, we might be able to do by way of court rule. And what we need to do is take a close look at the language of the statute and a couple of cases. In fact, there are only a couple of cases in California that interpret our statute relating to the openness of dependency proceedings, and that's Welfare and Institutions Code Section 346. So I took a look at these 2 cases, one an old Supreme Court case and another a Court of Appeal case out of San Bernardino, and it took me actually several reads because I am a little bit slow, and where finally the light went off and I said, I think we may be on to something here. And I really think that what's happened is we have not been looking at the statute in California in the right way. We talk about courts being presumptively open, presumptively closed, this, that, and the other. I don't see it where it says anywhere in the statute. I don't even see the word presumption in the statute. So if you look at the language of the statute, Welfare and Institutions Code Section 346, it says, unless requested by a parent or guardian and consented to or requested by a minor concerning whom the petition has been filed, the public shall not be admitted in a juvenile court hearing. So bottom line here, if the child consents, the public can come in. All right, that's pretty much what that says. And then it says, the judge or referee may nevertheless admit such persons as he or she deems to have a direct and legitimate interest in a particular case or work of the court. So if someone has a legitimate interest, the court can let them in. But what standard is the court using? And how is that going to operate? And what does that mean? Well, so we have 2 cases. The first case, Supreme Court case, that is called Brian W. versus Superior Court, for those of you that really need to know, 20 Cal 3rd 618, a 1978 case, and it dealt with a predecessor statute to Welfare Institutions Code Section 346. And what that case said is that we conclude that investing the judge with discretion to admit to juvenile court proceedings persons having a direct and legitimate interest in the particular case or the work of the court, it was the purpose of the legislature to allow press attendance at juvenile hearings. Now, mind you, that case and the other case, the San Bernardino case, San Bernardino County Department of Public Services versus Superior Court, a 1991 case, 232 Cal 3rd 188. Those 2 cases talk about the interest and the importance of the press having access, and it also talks about the interest of the public having access. But they talk about the press, they talk about the public. Our statute, of course, just says the public. And once again, that language that I quoted from you from the Supreme Court talks about the press. So, in putting all this together, now, once again, in the San Bernardino case, which said, look, we're taking this Supreme Court case and we're applying it to dependency court proceedings. The press wanted to come in, and the case, among other things, said the First Amendment doesn't apply here. But what they basically said in that case is the press should be allowed access, unless it is shown that it can harm the child. So, what I'm saying here is what I've attempted to do in Los Angeles, because once again, when the press shows up or to court proceedings in LA, and I'm sure this is the case in other places, sometimes they're let in, sometimes they're not let in. And it's never been clear why the decision has been made either way. It's never been clear what standard the courts have been using either way. And so what I try to do, at least in Los Angeles, is to establish a procedure that was clear and that everybody can understand. So putting all this together, essentially what I did was said, okay, here's what we're going to do in Los Angeles. Number one, we're going to presume that the press has a legitimate interest. Okay, so therefore they should come in, and I think that's clear from the case law that the press has a legitimate interest. Secondly, if they come in, or when they come in, if somebody objects, they have to show that it's going to harm the child, and if the court so finds, then they don't come in. But if someone can show that, they get to stay. Insofar as the public is concerned, once again, I have differentiated between the press and the public because the statute talks about the public. And so when a member of the public comes into court, they have to identify themselves. They have to indicate why they're there. The court has to find that they have a legitimate interest in being there, and if so, they can stay unless somebody objects and once again shows that their presence will harm a child, in which case then they leave. It's clear, it's simple. I think it's what the law is in California, and quite frankly, when I think about it, and after all this time, I don't know why I wasn't able to think about this years ago, but it appears that the law in California is a good one. When you combine it with the interpretations that the case law has given it. And so, since we didn't open the courts, so let's be clear. People say, Judge, you opened up the courts. I haven't opened up the courts. I don't have the ability to do that. The legislature has the ability to do that. I have established a process that provides for the access that is allowed under our law. It has perhaps, you know, depending on your perspective, loosened the reins a little bit. We have seen more folks from the press attend. I think that they have been responsible. The representative from the LA Times here today will give you his perspective. The LA Times has been very supportive of this notion, as you can imagine. But I also had a conversation with Jim Newton at one point. I said, look, it's great that you're supportive of this notion, but if you look around the United States, there are probably 20 courts or more that are open. And everybody says, well, nobody comes anyway, it doesn't really matter. Okay? And we're saying that it could matter. And the only way it could matter is if you keep coming. Okay? And for my money, they've come more since we've done this. They haven't come enough. I'd be fine with them there every day. As I said to Jim, there are 8 million stories in the naked city. Every time you come to court, you'll learn something more about this system that's worth telling the public about, and it can make a difference to those of us who work in the system. So I think that even if we just opened up the courts, in and of itself, that's not going to change anything. Well, I, as a judge, do, and I encourage my other colleagues around the state and around the country to do, is you're going to open your doors, you need to encourage people to come in so that you can potentially have that impact on our system by shining the light on the system. So that's it in a nutshell, and I know I've exceeded my time, so thank you all.
Thank you. And we'll have a chance for Q&A after this. I'm sure people will have some questions. And so I want to invite up Leslie Heimov, the Executive Director of the Children's Law Center of California, who, of course, her attorneys are representing children in those courts and has seen what's going on in LA County and has a perspective on that too. So we're very happy to have you, Leslie. Thanks for coming out.
Thank you, Daniel. Hello. So I was told that I'm supposed to talk about our experience so far, and then, of course, our perspective more generally on this topic. And I'm actually glad that Judge Nash said that he hasn't opened up the courts. My people will be thrilled to find out that they're not open after all. Seriously, I do think that one of the problems with this whole topic is that the debate is often framed inaccurately. I agree, the question is not open or closed, because the courts, at least in Los Angeles County, have not, in the 20 years that I've worked there, been closed up tight like a drum ever. We've had people that are not parties and are not lawyers in our courtrooms every day. in almost every courtroom and almost every case, whether it's relatives or teachers or friends or coaches or therapists or the press or interested citizen groups or whatever, or legislators and their staff, or whatever it may be. Our courts have been quite open to those that have taken the time and the interest to use the previously existing process to access the courts. And I think, as Chantel said, that for us the question is more what is the proper method to access, and how do we allow the access without compromising the quality of the proceedings and the privacy and respect for the children and the families that we're serving. Daniel started out by saying that he thinks the biggest challenge to reform is the general public's lack of understanding. I'm not sure that I agree with that, or I would say I respectfully disagree. Voiceless, powerless constituents are still going to be voiceless, powerless constituents, whether or not the courts are open or the media has greater access, because the people we're talking about are children with no political clout and poor families with no economic clout, primarily. And those people have been well known to the public as existing with or without open dependency courts, and continue to have little power in the places where power is held in terms of the legislature or other. And as a couple people have pointed out, our system is sorely under-resourced and underfunded. And as a result, it's difficult for anyone, even the best intentioned, most capable, most competent lawyer, judge, or social worker, with or without the media watching, to do their jobs as well as we would like to do them. We often hear of studies. There's one study that found that in Los Angeles, given the number of children in our system, that we should have 44 dependency courtrooms operating on a full-time basis. We have 20. Children's Law Center, who represents almost 27,000 children in the dependency system in Los Angeles County, should have 160 lawyers to have adequate and reasonable caseloads, according to a study by, ironically, the Humane Society. And we have 120, because that's what we're funded for, and don't have the ability to increase that. So for all those reasons, I'm not sure that opening the courts or having easier media access is going to make any difference at all, even if it's the best reporting in the world. So what's our experience been so far? In the first few weeks, it was extremely chaotic. People were frenzied pretty much everywhere, all day, every day. All of the lawyers from both the parents' firms, county counsel, and the children's law firm were scrambling to try to figure out what the procedure is or was or should have been. As you may be aware, there was a hearing, an open hearing on the proposed blanket order, and about 9 hours later, the blanket order went into effect. So though we had access to the order in advance, we didn't have a lot of time to figure out exactly what, since we didn't know exactly what would happen, exactly what the procedure would be. Although there's less traffic now, there's still very little procedure, actually, in terms of the day-to-day. There are no rules with regard to what someone is supposed to do when they come into the courtroom. So the public and the media are generally free to come in and take a seat. In most of our courtrooms, the bailiffs are not inquiring as to who they are. Prior to the blanket order being issued, every time anyone who was unknown to the bailiff walked into the courtroom, they were asked, who are you, why are you here, what case are you on? That is not happening in many of the courtrooms, and it's completely case by case, depending on the judge's preference and that particular bailiff's practice. So for the attorneys, one of the challenges, the attorneys for the children, who carry the primary burden of determining whether the argument should be made that persons would, on this particular case, harm this particular child, is that we don't always know who's there. And for those of you who have been to the Los Angeles County Court, similar to this, if I were the judge and you all were the lawyers, the door's back there. So you can't see who's coming in unless you turn around every time the door opens, and the door opens about every 15 to 20 seconds in our courtrooms. So it's basically impossible for the attorney to keep track of who's in the courtroom and who they need to be making the inquiry of. So there's some, in terms of process or lack of process, there's a lack of process there that could probably be remedied, and some of the things in the Code of Ethics, like announcing oneself, would help with that. The other issue, so that's one of the sort of day-to-day nuts and bolts issues that we're dealing with. The other irony, I think, in what's happened in the past year since the blanket order was issued is that because we have what I would call a very sophisticated bench, we have a well-trained bench, and I think highly trained lawyers as well, There is attention on a case-by-case basis when we know that the media or public is there to evaluate and make the proper legal arguments, and generally when the minor's attorney asks for the hearing to be closed, it is. So as Judge Nash did say, it's not wide open where the press are in no matter what. I don't think that that's necessarily the case in every dependency court throughout California, and certainly not throughout the country. In some smaller jurisdictions in particular, there's circuit judges where it may be a different judge every time the child comes to court, or the judge who's hearing the dependency cases only hears 10 or 20 or 10 dependency cases in a month. Or 5 in a month, whereas our judges hear them. That's all they do all day, every day. So they may have a greater sensitivity to the issues and to the circumstances of that individual child. In some jurisdictions, children have no lawyers. So if we were to see a situation where even just the blanket order was enacted throughout the country, there would be courtrooms where the child has no lawyer at all to make that argument for them that the media shouldn't be there. So Los Angeles and California, because our system is more sophisticated, is, I think, differently situated than perhaps some other parts of the country. It's also been suggested by our host that we all might agree that openness will lead to system reform, but I think the little bit of evidence that we have is that it hasn't in the jurisdictions where there has been a more open proceeding. The 2 cases of research that we have that Jamie reported on have shown it's had no significant impact on reform at all. So I think in closing, from the Children's Law Center perspective, we're fairly aligned with CYC in that we feel that the most important factor is that the child has the information needed, not just the legal ability, but the actual information needed to determine whether the argument should be made, and that we have to have the resources and the time and the preparation to be able to form those arguments and really look at each case individually and with adequate ability to prepare and present the appropriate arguments to a well-informed and well-trained bench.
If we could have Jim step up here. Jim Newton's been covering, so we've talked about some of the issues that are going on in the court in LA County, and Jim's probably been covering it more than anybody else at this stage, and very thorough reporting. So we're very happy to have you. Thank you.
Thank you. All right, so I prepared some remarks for today, and then I got last night an email and a follow-up this morning that caused me to sort of reconsider how to present this to you. So let me just read this to you. Of course, it demands finding it. I didn't realize I was up quite this quickly. Give me 1 second. This is from a lawyer in a case that I covered early on, taking advantage of the order, in which there had been a number of delays. She was representing a little girl who's about to turn 3 years old. This little girl has been in the system her whole life. She was placed in foster care when she was 7 days old, and she remains with that foster family. That foster family, excuse me, was trying to adopt her, and the case just there was delay after delay, and that's why I wrote a column about it. Fairly critical, frankly, of the judge, of the birth parents who had been cycling through lawyers, which is what caused these repeated delays. And the result, of course, is this child was missing an opportunity to have her infancy in a stable home. Well, the case yesterday was resolved, and the lawyer, her name is Deborah Detler, sent me a note this morning. She says, "Feel free to mention my case today as an example of where media coverage made a profound difference. The case was just chugging along with endless delays until you showed up. And yesterday, when the final ruling was made, as the child approaches her 3rd birthday, the new judge and attorneys knew about some of the problems in the case because you had mentioned them in an article." So that may not be system reform, but that is change. And that is change that is the result of a reporter being present. You know, and I think, obviously I'm proud of it, but I also want to cite it because I do think it's illustrative of what can happen in this system. A couple other points I'd just like to address. I think there's an assumption that runs through much of this conversation that parents, children, foster parents, that they're the ones who are most demanding privacy. For what it's worth, that has just not been my experience in this past year. Whenever I write a piece, I've written about 6 columns. I write a weekly column for the paper. Whenever I've written a column about being over in dependency court, I am deluged with emails from people who are in the system and feel terribly abandoned and alone in it. And they want coverage. They're begging for coverage. There's far more than I could ever do, notwithstanding Judge Nash's repeated attempts to get me to do so. Several times, in fact, I've had lawyers for parents in particular object to my presence in the courtroom. The objection's been overruled, and then during the break, the parents come to me and ask me to write about the case. That actually occurred in the case that I just described, in fact. Those who have been most offended by my presence in the courtroom over the past year have been lawyers, social workers, and sometimes court officers. Those are precisely the people who need to be held accountable in this system. So their objections to my presence, I would argue, are all the more reason why reporters like me and others should be present. There is, of course, a need to be careful in these proceedings. It is easy to imagine the careless story that will cause harm to a child. It is obviously important to be careful with children's names, and I'll get back to the Code of Ethics here in a minute. But it's also, I think, important to recognize that secrecy is not free in this system. That this system, by being relatively closed, has a cost as well. The system right now is very good at protecting the identities of children, but it is very bad at protecting the welfare of children. And I do think that that balance is lost in this conversation often. The errors by social workers and others are underreported. We know less about them than we should by not being present in those courtrooms, and therefore we know less about how to fix them than we should. Political priorities, I do think, are skewed by this system being largely off the sort of public radar. You know, police coverage, and police are open institutions in most places. You can cover police work extensively, we do, and police officers and police departments are lavishly funded. This system is not well covered, and it isn't. And finally, I think the last cost in terms of reporting is there's a certain amount of distortion in our reporting and in a lot of people's reporting on this system. And that's because it's heavily tilted toward children who die in the system, because at that point those records do become public. So if you read our coverage over many years of foster care, you would think that it was dominated by the deaths of children. Well, there's a whole system of, there's successes obviously in the system that are really almost never reported because we can't or haven't been able to until recently. So finally, the Code of Ethics. I certainly am not going to argue that journalists should not be ethical. I happen to write the Code of Ethics or the ethical guidelines for the Los Angeles Times. But I do disagree that subscribing to this Code of Ethics or any Code of Ethics ought to be sort of the price of admission into this system. I think that that suggests that, access is a gift to the press, and it isn't. Access is a safeguard of the system. And yes, reporters who go in there should behave ethically, they should always. But I don't think that they should have to sign a document or agree to adhere to a particular code in order to gain access to these proceedings. We should recognize that access is for the benefit of children and others in the system, not just for reporters. Anyway, with that, I'll close. Thank you.